remains a valid treaty and that violations may be fixed through domestic constitution reform and political negotiations. So before I proceed, Professor Henning, I wish to introduce myself. My name is Woon Lee Shan. I'm a retired government servant. But I did make some research about the formation of Malaysia. After the World War II, the United Nations General Assembly passed Resolution 1514 and 1541 to decolonize all colonies on the ground that colonization is against human rights, is a form of slavery. That is the gist of 1514, 1541. So due to that, we were at the time I was a very small boy. We don't know anything. The British gave Malaya independence first. I don't know whether it's planned or not. Then later on, handed this Sabah, Sarawak, and Singapore to Malaya. To what I understand at that moment, Lee Kuan Yew did ask for independence together with David Marshall, but was not allowed. So with that, I think Lee Kuan Yew knew that the British wanted that Sabah, Sarawak, and Singapore be handed over to Malaya. So from what I could understand, Malaya was given these three territories. There is North Borneo at the time, which now we call Sabah. The other one is Singapore, and of course Sarawak. Brunei didn't come in. So we saw that in order to overcome this problem, the British constituted this Cobble Commission. The Cobble Commission came with the Cobble Commission report.
Sorry, Mr. Boon. I know it's very important topics. Can we get to the questions? I'm sorry to cut you short, but can we get to the
No, I have to lay down the groundwork first, okay? And then we understand, Professor, that we never formed Malaysia. Sabah, Sarawak, Singapore never formed Malaysia. We never joined Malaysia, but we were acquired by Malaya through what I can say a dubious Malaysia agreement to enlarge Malaya with a new name, Malaysia. We can see that this is in the record of the United Nations Secretariat. We can refer this in the United Nations Juridical Year 1963. With that, Professor, there was a legal opinion by the UN Secretariat to say that Malaysia is not a new country. It is not a new federation. So we retain the same registration number in the United Nations. So there is no new federation, no new country. And I would respectfully say, without the Cobble Commission, there is no Cobble Commission report. Without the Cobble Commission report, there is no intergovernmental committee. Without this, we also cannot have the Malaysia Agreement. Okay? But now, the validity of this Malaysia Agreement is what we have been talking about for so many years, so many decades. And we can see that this is a way of colonization or neo-colonization by Malaya of the state of Singapore, Sarawak, and Sabah. How could this report mention that out of 1 million plus of the population of Sabah and Sarawak at that material time, only 4,000 people that were interviewed. And then 1/3 agreed Malaysia to be formed. 1/3 said condition must be imposed. 1/3, the other 1/3 totally disagreed Malaysia to be formed. What is the legality of this thing? If this Common Commission is not proper or the report not proper, meaning that the Malaysia agreement also is not proper. It is a fruit of a poison tree.
Yeah,
When this is a fruit of the
sorry,
poison
just
tree,
to cut you
no,
again.
I have to start with this.
Yeah, sorry,
Yeah.
because we are not
No,
yet.
what we are talking here,
We can have
we
another
understand
section
here.
for debate.
You are talking that the Sarawak now, the federation is valid, which we dispute that is invalid. It is null and void ab initio, Professor. The Chagos Islands case delivered in 2019 is quite clear to us. So I don't want anything that's our stand. This is my stand for many years already with other people who believe that Malaysia was not properly constituted. We consider that the Malaysia agreement very dubious. Very dubious. The Common Commission report was some sort of like a fraud like that. With that, I think what the professor said, secession is one of the solution for the current situation. Can you please say, Professor, whether Malaysia agreement is valid or not, whether Malaysia Federation is properly constituted under the international law. Thank you very much.
Well, thanks for your passionate intervention. As I suspected, I mean, you've got people who want to invalidate the Malaysia Agreement and other people who want to see it fully implemented. And these are obviously inconsistent positions. I mean, if you like, we could go into a discussion about the Chagos case and whether that supports the position that you mentioned. I think many of the points you make are absolutely right and are actually supported by the two interviews that I mentioned just now. I think there's a strong case to say that there wasn't real consent to it. But then, going beyond that, I mean, we are where we are, whether we should be or we shouldn't be. The fact is that we are, and so there's got to be a decision about, well, do you go down the route of saying that, well, we're entitled to independence because this was all invalid at some point in the past, and it is getting quite remote in the past, 1963 now, or do we sort of accept the position, the de facto position that we have, even though we may have doubts about its actual validity in the historical and legal sense, and ask the question, well, how can we make the best out of the situation that we've got, in order to persuade those who would need persuading that your position is right. And as I've indicated, I mean, I agree with a lot of what you've said. I mean, historically, I mean, there's a lot to be said for that. I mean, it's a big cliff to climb to convince, the federal government, to convince a court of law, in terms of international law, because, well, there are a number of reasons why the Chagos case is arguably not wholly applicable to Sarawak. But I would go beyond that to say, think about the practicality of pursuing this line of argument. Because if you compare with the Chagos Islanders, I don't know how long they have been pursuing this litigation and their grievance over what happened in the past. But it's certainly taken longer than 15 years, maybe 20 years, and they still haven't got what they wanted. If you want to argue this in terms of a court decision, and that's the only way you could get a legitimate kind of answer to your question, really, through a court, because I mean, my opinion wouldn't count, either way on this. So you need to go to court over it. There are formidable obstacles both in the law and in the practicality of what you're doing. And basically, you would have to get